Should we start? Can we start?
Yes, sir.
Okay. So we were done with trespass. Trespass to body was also covered. And trespass to land was also covered, as far as I remember. I think we have to start with, did we cover trespass to movable objects as well?
No, sir.
Fine. So we'll start with trespass to movable objects. Movable property. Okay. So we all know what trespass is and what are the essentials of a trespass, or what are the essentials of the tort of trespass. Now, trespass, we studied in the previous class that it can happen either against the body or against the person. Sorry, against the person or against the property. Now, within the property, there are again two situations, that is trespass against movable object, or trespass against movable property, or trespass against a immovable object or immovable property. So as far as trespass to movable property is concerned, it is called as trespass to goods in simple terms, because goods are in essence are movable objects. Now, what does it say? It says wrongful or unjustifiable interference with the possession of goods of another. Now, what are the keywords here? Yes, can you guys identify? What are the keywords? Komal and Prarthi.
Wrongful, unjustifiable, interference, and possession of goods of another.
Okay. So you have reiterated the definition. There are four keywords: wrongful or unjustifiable, interference, and possession. Now, why possession is important? Because even when a person may not be the owner of the goods, but he's just keeping the goods, then also a tort of trespass can be committed against him with respect to movable object. Now, can there be a situation where a trespass to immovable object, that is land, can be committed by the owner of the land against the user of the land? Is it possible? Let me rephrase my question if it is not clear. Can the owner of the land commit a tort of trespass against the user of the land? Okay, the answer is yes. Why? Let's take an example. Suppose I am the owner of the land and I have a tenant, and I enter into the premises where my tenant lives unjustifiably. In that situation, again, I have committed a tort of trespass. So remember that trespass is not against ownership. Trespass is an offense against or a tort against possession. Am I clear? Am I clear? Fine. Now, similarly, trespass to movable object can also be committed against goods of another, that is, against the possessor. Now, trespass to goods is again categorized into two categories, detenue or conversion. We'll get into the details of each of them. Detenue, as the name suggests, means detention. And conversion means using it for your own use. We'll get into the details. Let's first discuss detenue. What is detenue? Wrongful detention by the defendant of the goods belonging to the plaintiff. That is, the defendant should have detained the goods and the goods should belong to the plaintiff. The goods must be acquired either wrongfully or rightfully. So basically, how you have acquired the goods, that does not matter. What matters is who has the or who had the possession at the time when the tort was committed. So it is a tort against the possession and not ownership. Remember this. Now, what are the essentials to prove the tort of detenue? Plaintiff must prove possession of goods. मतलब आपके पास goods थे. Plaintiff जो है उसने डिमांड किया हुआ करे कि goods जो है वो रिटर्न कर दे डिफेंडेंट, and defendant refuse कर दे to return the goods, and then the plaintiff sues for restitution of specified goods and not merely damages. Let me give you an example. Suppose I'm sitting in the classroom, one of you came and asked, sir, can I have the pen? I said, okay, I take it. You took the pen, never returned it. I asked you, return the pen that you have taken, or return the pen that you took. So in that situation, the moment you have refused, that very moment the tort of detenue has been committed. Am I clear?
Yes, sir.
Fine. Then comes conversion. What is conversion? Conversion is a tort where intentionally and without lawful justification dealing with goods of another person in such a manner that the person entitled to use and possess the goods is deprived of them. It is a tort against ownership and not merely against possession. So there is a difference in detenue and conversion. In conversion, the tort can only be committed against the owner. But in detenue, the tort can even be committed against the possessor. So that is an important aspect that needs to be understood. What are the essentials? Dealing in a manner inconsistent with the rights of the person entitled to do it. In conversation, conversion, no, intention is not necessary. Okay, yeah, intentionally, yes. Yes. On purpose, basically. It has two requirements, intentionally and without lawful justification. Right? Dealing in a manner inconsistent with the rights of the person entitled to it. Intention in doing so is to deny that person's right now. So dealing in a manner inconsistent with the rights of the person who was entitled to it. That means जो आपने rights दिए थे उसके लिए आप entitled नहीं थे and still the person used it. Then intention in doing so is to deny that person's right. Now आपकी जो इंटेंशन थी वो ये थी कि जिससे जो सामने वाला व्यक्ति है उसका राइट जो है वो डिनाय हो जाए. Let's take a simple example. Suppose you have given your car to Mr. X. उसने बोला कि सर मेरे को जाना है एग्जाम देने तो मैं आपकी गाड़ी ले जाऊं क्या? I said fine, take it. He took the car and now he is not returning. He rather took the car from, for example, Jaipur to Agra. Although the permission that was given to him was only till Jaipur. Right? So the moment जो उसकी परमिशन दे रखी थी उसको राइट यूज करने के लिए उससे आगे निकलता है वैसे ही कन्वर्जन हो गया. Then that means he has converted the goods for his own use now. Am I clear?
Yes, sir.
Fine. Now comes a very interesting tort, which is defamation. What is defamation? Yes. What is defamation? Just tell me in simple English. Prarthi and Komal. What do you understand by the term defamation? Destruction of reputation. Okay. Yes, Komal. To harm one's reputation. Very right. Now, why do you think that reputation has been made a tort? That right to preserve your reputation has been made a tort? Why? what would happen if someone's reputation is tarnished or is damaged? Respect. Okay. Why respect is important? Exactly, because respect is important to live in a society. And that is the reason why defamation has been made a tort in law of torts. What is also very interesting to see is that tort of defamation is also a crime. That is, it can also result into a criminal case against a person. Defamation basically prohibits that no falsehood shall be propagated against a person. The tort of defamation says what? Defamation is damage to the reputation of the plaintiff in the eyes of the general members of the society. Right? So, the loss of reputation to constitute defamation must be in the eyes of the general members of the society. That is, the people who are the right thinking members. So, suppose if there is a mental asylum and that believes that Mr. X is married to Miss Y, and both of them are not married actually to each other, is it defamation?
So could you repeat?
I'm saying, suppose in a mental asylum, the mental patients think that Mr. X is married to Mr. Y. Sorry, Mr. X is married to Miss Y. Would it amount to defamation with respect to Mr. X and Mr. Y? Sorry, Mr. X and Miss Y. No. The reason being, it was thought by exactly because it is thought not by the right members of the society, but by people who are suffering from some mental disease. So in such a situation, what they think cannot be considered as defamatory. Now, what are the essentials? There are 4 essentials to fulfill defamation or to constitute defamation. What are these? The statement must be defamatory. That is, it should lead to loss of reputation of the person. The statement must be false. This is very important. Can a true statement ever be defamatory? No. Right. Suppose if I say that a particular godman, religious godman, is actually a criminal, and I say that, and that person turns out to be actually a criminal. Will it amount to defamation? No. Right. Why no? Because it is not false. So the statement must be defamatory and the statement must be false. Third one is the statement must refer to the plaintiff. This is very important. What is law of torts? Is it a civil law or a criminal law? Civil law. Very right. So in a civil law, there are 2 persons who are involved. The one to whom the damage has been caused and the other one to whom and the other one who has caused the damage. Now, that is the reason why statement must refer to the plaintiff, because till that time it is not referring to a particular individual. There cannot be a tort of defamation that can be committed. So suppose if I say all lawyers are liars, will it amount to defamation?
So would you repeat?
If I say all lawyers are liars, if I say all lawyers are liars, would it amount to defamation? Okay, why yes, Prarthi, and why no, Komal? It is not true in all the cases. What do you mean by that, Prarthi?
Sir, it might not be always true that a lawyer is a liar.
What do you mean? That's what I'm saying. It is. Does it sound defamatory?
No, it doesn't.
Why? Let us assume that it is false. Then also will it amount to defamation?
No.
Okay. It is not defamation. Why? Because the statement does not refer to a particular individual. Suppose if a statement is made, there is a lawyer named Mr. X who practices in this high court is a liar. Then it can amount to defamation if it is not true, right? But just saying all lawyers are liars, that would not amount to defamation. Okay?
Yes, sir.
Then comes statement must be published. What do I mean by the term published? क्या लगता है आपको? What do you understand by the term published? Yes, published means it should come to the knowledge of third person apart from the plaintiff and the defendant. And the communication must be made by the defendant. Publication can either be in oral form, it can also be in written form. Publication को ऐसे समझने की कोशिश करें जरा. Suppose I tell Mr. X that Mr. Y is a liar. Would this amount to defamation if all the other essentials are fulfilled? No. Why, Prarthi? Yeah. So it will amount to defamation. Now, similarly, can you repeat the example? The example is simple. I tell you that Prarthi is a liar. Will this amount to defamation? Why? Why it will not amount to defamation, Komal? I didn't understand the example. Suppose, Komal, as I tell you that Prarthi, the other student, is a liar. So, have I committed defamation against Prarthi? Yes or no? Is my question. Yes, that is exactly. Why? Because all the essentials are fulfilled. The statement is defamatory. The statement must be false. The statement must refer to the plaintiff, and the statement must be published. So, the moment all the essentials are fulfilled, that very moment defamation has been committed. Now, suppose I'm shouting in an auditorium. Okay, listen to the example. Suppose I'm shouting in the auditorium and the auditorium is closed. There is no one in the auditorium. But somehow somebody who was standing outside the auditorium heard that I'm saying bad words about Mr. X. Will it amount to defamation? Okay, the answer is no, it will not amount to defamation. Why? Because there is no communication on your part to Mr. X. Exactly, very right, Gomal. So, since you have not communicated it, it cannot be said that you have published it. Right? Now, let's take another example. Suppose I write a letter to Mr. X. The letter is in Hindi. I very well know that Mr. X do not read and write Hindi. So he will need help of someone, Mr. XYZ. I write a letter which is very defamatory. As always, he didn't know how to read and write Hindi. He asked Mr. Y to read the letter for him. Mr. Y reads the letter. Now, in this case, defamation has been committed or not? Yes, very right. Both of you are very correct. Defamation has been committed in this case. Now, suppose there is a letter written by Mr. X to Mr. Y. Fine. Letter written by Mr. X to Mr. Y. Instead of Mr. Y reading it, his wife reads it. His wife reads it. Will it amount to defamation? Okay. It will still amount to defamation. Why? Because the matter has been published. It may look like very strange. Yes. Although it was written for Y, still the letter can be opened by anyone. And that is the reason why it may still amount to defamation. A situation would be different where suppose Mr. X and his wife, they are discussing about Mr. Y. And Mr. X says that Mr. Y is the worst person that can exist on this world to his wife. Will this amount to defamation? Just class, what do you think? Will this amount to defamation? Mr. X and his wife are talking about Mr. Y. Okay. This will not amount to defamation. Why? Because communication between husband and wife are privileged. So in this situation, it would not amount to defamation. So it's very interesting. If somebody says something about your husband or wife to you, it may amount to defamation. But if the husband and wife are talking about a third person, it would not amount to defamation. Yes, there is another exception to this rule, which is client and advocate. So when a client meets his advocate, the communication between them is privileged. That means it cannot be considered as defamatory. Am I clear? Okay. So suppose I write down an article. तो अभी किसकी शादी हुई है? For example, सिद्धार्थ मल्होत्रा and Kiara Advani, right? So suppose I write down an article wherein it says Siddharth Kiara gets married in Rajasthan, etc. And then the photo of the wedding is also provided. And in the photo, what has happened actually, I have provided a photo of Siddharth Malhotra with Alia Bhatt. Am I clear? Yeah. So will it amount to defamation on part of the newspaper? Suppose it came in the newspaper. Yes. So even though it was a mistake, genuine bona fide mistake on part of the newspaper, still it will amount to defamation. So the moment there is something that is defamatory, it can, and if it fulfills all the other essentials, the tort of defamation is committed. Now suppose there is a character named Mr. X is shown in the movie. The character that has been shown in the movie exactly resembles a person named Mr. Y or named Mr. X in the city of Jaipur. Will it amount to defamation? Okay, I'll repeat the example. Suppose I make a movie wherein I depict a character of Mr. X. And he is he's basically the villain of the movie. Very bad character I have shown of Mr. X. This guy, Mr. X, resembles a person in Jaipur who is exactly like him. Now, this person in Jaipur, can he file a case of defamation against me if I am the director of the movie? Will it amount to defamation? Why no and why yes?
So could you repeat?
Could I repeat? Why you guys are not able to listen to me carefully or what?
No, so actually the flow of your voice is breaking continuously. That's why.
Perhaps maybe because of the internet connection at your end.
Yes, sir, maybe.
The question is, suppose I make a movie wherein I depict Mr. X as a very bad human being or as a very bad character. The characteristics, etc., that I have attributed to him resembles exactly to a person who lives in Jaipur. Now, can this person who lives in Jaipur file a case of defamation against me? Okay, why Prarthi? Why yes? Okay, right. It would still amount to defamation. Why? Because it has caused loss of reputation to that particular person, and the general public thought that this character is actually this particular man who lives in Jaipur. So that is the reason why it can be considered as defamation. Very right. Any doubt? Any confusion? Then comes defenses to defamation. Or I'll do the types first. Let's do the types first. So there are three types of defamations, or there are three kinds of defamatory statements: libel, slander, innuendo. Libel, slander, innuendo. These are the three types of defamations or defamatory statement. What is libel? Libel is basically a situation wherein defamation is caused in a permanent form. What do I mean by that? What is permanent? Something which is in written form is permanent. So suppose I write a defamatory statement in the newspaper, it is libel. Suppose I write a defamatory statement in a newspaper, it is libel. I put a defamatory advertising board, that would also be libel. Now, you need to understand that with that change in technology, things which were not, or things which could not be made into a permanent form has now actually been made into a permanent form. How? Earlier, you cannot record the voice of person, but now it is possible. So suppose you record the voice of a person and publish it XYZ places. It is libel, yes or no? Yes, fine. So in a WhatsApp group, if somebody says something, that would again be a defamation, and that would still be in the label form. क्या WhatsApp मैसेज डिलीट करने के साथ डिफेमेशन भी खत्म हो जाता है? Right. So it would still be a defamatory statement. Very right. Then comes slander. So slander is something which is in non-permanent form. That means either in oral form or in gestures. Can slander be in gestures? Can slander be through gestures as well? Right. So, you know, like there are certain gestures which are considered inappropriate, considered abusive also sometimes. So they can fall under the definition of slander. Third one is innuendo. What is innuendo? Innuendos are basically innocent looking statements having a hidden defamatory meaning. Innuendo are innocent looking statements having a hidden defamatory meaning. That means the person said something, but he meant something else. So suppose if there is a statement that Mr. X's son looks like his neighbor. This is defamatory statement, right? So these are innocent looking statements which have hidden defamatory meaning. Another example of this could be if I have friends like you, or if I have a friend like you, I don't need an enemy. That can also be considered as innuendo. Yes, are the types and the essentials clear? Then come defenses to defamation. What are the defenses? The first defense is the best defense, which is truth. Truth is the best defense. If you are saying true, something, if you're saying something which is true, then it will be not be defamation. The second one is fair comment or opinion. Now, this is interesting. What is fair comment or opinion? A fair comment is a comment which may be unpalatable, but have reasons to justify it. What do I mean by that? Let's take an example. Suppose I write an article in the newspaper saying that Narendra Modi's government is the worst government that has ever come to India. Or Narendra Modi is the worst prime minister that India has ever had. And then I state 5 reasons that why is the worst prime minister ever. Can Narendra Modi file a case against me? for defamation? No, because you mentioned the reason exactly. So always remember that defamation is not, because defamation is always going to be in conflict with your right to freedom of speech, right? Because ultimately freedom of speech on the one hand says that one should speak his mind, whereas defamation says that one can say whatever but cannot be defamatory. So it's kind of a reasonable restriction in that sense. Then comes privilege. Now privilege is also of two types: absolute privilege and qualified privilege. What is an absolute privilege? An absolute privilege is a privilege which gives you a complete protection against defamation. That means you can say whatever you want to say and still not be held responsible. Example, or not only example, actually the only people who have who have absolute privilege is actually a speech made in the parliament or the legislative assembly. A speech in the parliament or the assembly is completely a free speech and it cannot be questioned on the ground of defamation, right? So the tort of defamation is not applicable. Tort of defamation is not applicable to parliamentary speeches. That is the reason why you will see that in parliament, a lot of criticism takes place, which is very abusive also sometimes, and which is very harsh, right? But still no defamation cases filed against the member of the parliament or the member of the assembly. Am I clear with absolute privilege?
Yes, sir.
And then comes the qualified privilege. What is qualified privilege? Qualified privilege is a privilege which exists because there was a necessity to tell something. The best example of qualified privilege is actually press. Press क्या करती है? उनको कोई इंफॉर्मेशन लगी कि ऐसा हो सकता है. Now that information need to be relayed or need to be given to the general masses as well. So what they will do is they put either a question mark or they put an exclamation mark. Now, by putting a question mark or by putting an exclamation mark, it does not become a statement. Rather, it becomes a question. Have you guys seen the movie Sanju? Right. So in the newspaper, you must have seen that, Sanjay Dutt the terrorist hai. So what they did, Sanjay Dutt terrorist hai, and then they put a question mark. Yeah. So that is how newspaper walas escape liability. Although why they were able to publish such a report is because they thought that a banned weapon is being found. So most necessarily or most likely there can be some terrorist link. So just on the basis of presumption, sometimes also the news publishing can be made. Is it clear? Is defamation clear? Any doubt? No, fine. Then we'll move to the next topic, which is malicious prosecution. Now the word malice, it is composed of two words, malice and prosecution. Now what is malicious? Malicious is something which is done with bad intention or with a intention to cause harm or without reasonable justification. Malicious prosecution as a tort can only come into play once there has been a criminal case that has been filed against you for no reason whatsoever. What does it say? If a person files a criminal case against another person whom he knows to be innocent, very important, whom he knows to be innocent, that means it is an intentional tort. Can I say that? Right. So it is an intentional tort. And without a reasonable belief, think that he has committed the crime and it results in prosecution of the person. Now, what is prosecution? Just understand it. Try and understand it. Prosecution कब माना जाता है? जब ट्रायल हो जाए और ट्रायल चले और ट्रायल चलने के बाद एक्विटल में डिसाइड किया जाए. Mere registration of FIR is not prosecution. Remember this. Am I clear? Mere registration of an FIR is not prosecution. So what is prosecution? Suppose I file a criminal case against Mr. X. I filed an FIR rather. And in the FIR itself, the police said that no, he has not committed the crime. Can it be considered as malicious prosecution then? I don't know about that, Komal, that whether it is in the book or not. So in this situation, what would happen is the person would be held liable. Sorry, would not be held liable for malicious prosecution because there is no prosecution. So what are the essentials of malicious prosecution? There must be a prosecution. The prosecution must be without reasonable and probable cause. The plaintiff was prosecuted with malice. It must result in the acquittal of the plaintiff. And plaintiff need to have suffered damage as a result of the malicious prosecution. Now, let's take an example. Suppose me and Mr. X are office colleagues. मुझे पता चलता है कि मेरे ऑफिस में कोई क्राइम कमिट हुआ है. मिस्टर एक्स और मेरी ना बनती नहीं है बिल्कुल. वी आर एट लॉगर हेड्स विद ईच अदर. In such a situation, I file a criminal complaint against Mr. X and the prosecution takes place, and in the prosecution he was found to be not guilty. Acquittal. Can I be held guilty for malicious prosecution? Yes. The reason being, why? Because I had no reasonable ground or reasonable belief to think that Mr. X has actually committed the offense. Now, suppose me and my neighbor have a very bad relation and we are always fighting with each other. At 10 p.m. in the night, I saw my neighbor standing next to my car. And at 11 p.m. when I went to the balcony of my house, or went into the balcony of my house, I found that my car is not there anymore. I filed a complaint of theft and I made this guy, my neighbor, as the prime accused. Everything happened, FIR happened, etc., etc. Prosecution also started. The court found him not guilty. Can I be held guilty for malicious prosecution in this case? No. Prarthi says no. Okay. What about you, Komal? Okay. The answer is no. Why? Because I had a reasonable reason to believe that he might have committed the theft. Why? Because he was the last person whom I saw with my car. So I have a reasonable reason to believe that he might have committed the crime, especially when I know that me and my neighbor are not on good terms. And he was the last person whom I saw with my car. So the chances are high that he might have committed the offense. So that is the reason why it will not amount to malicious prosecution because there is a reasonable belief. Now, let's take another example. The example is, suppose there is a conviction from the lower court that is my neighbor has, same example दे रहा हूं मैं, वही क्या कहते हैं कार वाला, थोड़ा सा चेंज कर देता हूं, इसमें कोई मेरे पास रीजनेबल बिलीफ नहीं था, ठीक है। ये मान लीजिए कि ही वॉज नॉट स्टैंडिंग नेक्स्ट टू माई कार, now in this situation the lower court finds my neighbor guilty. Fine. Lower court finds my neighbor guilty. And then he files an appeal against the same order, against the same judgment. And the High Court turns the conviction into acquittal. मतलब High Court ये कहता है कि भैया नहीं कोई offense नहीं बनता. And the person is now free. Now, can I file a case of malicious prosecution? That I have been wrongly prosecuted? And then Prarthi, suppose मैं उसको challenge करता हूँ सुप्रीम कोर्ट में, सुप्रीम कोर्ट कहता है no, there is conviction, उसने crime commit किया, then what would happen? तो फिर malicious prosecution दोबारा ड्रॉप हो जाएगा. No, the answer is once you have been convicted, right? Once you have been convicted by a court, that means now no malicious prosecution. ठीक है? Is it clear? It is very essential that the plaintiff must have acquitted. That means must have been free from all the guilt. So that is the reason why. Can you briefly explain it? Explain what? I briefly explained in the slides. Read them. That example. The example is simple. Suppose I have filed a complaint against you, and then the lower court finds you guilty of the crime. ठीक है? उसके बाद आप उसकी अपील करते हैं. And then the High Court says, no offense, you have not committed any offense. Now, after being acquitted by the High Court, can you be held guilty for committing? Can you file a case of malicious prosecution against me after being held not guilty by the High Court? Now clear? कोमल, यस, सो व्हाट इज योर आंसर? क्या आप केस फाइल कर सकते हो अब मेरे अगेंस्ट? Answer is no, you cannot. Once you have been convicted, you cannot file a case of malicious prosecution. Understood? एक बार अगर आपको सजा मिल चुकी है तो फिर आप कितनी बार भी नॉट गिल्टी की करा जाए, यू कैन नॉट फाइल अ केस ऑफ malicious prosecution against me. Yes, any doubt with respect to defamation and malicious prosecution? Any doubt with respect to trespass?
No, sir.
Fine. So we'll stop here today. Next class we'll be starting with negligence. Negligence वाली class बहुत important है because it's a very long tort. ठीक है, काफी कॉम्प्लेक्स चीजें हैं उसमें, तो उसको थोड़ा ध्यान से अटेंड करना. ठीक है, that's all from my side. Thank you.
Hi, sir. Thank you, sir.